Welcome back, everybody, to Constructive Uncoupling, a podcast devoted to amicable divorces. I'm Judy Weigel, your host and amicable divorce expert. Why? Because that's all I do, amicable divorces, as a divorce mediator and a document preparation company. The title of today's podcast is Behind the Divorce Curtain, the Reality of Judges' Rulings. The purpose of this episode is to align litigants' expectations realistically for their day or days in court. And litigants can be self-represented or represented by an attorney. It doesn't matter. But we have to align the realistic expectations so that people know how to prepare themselves and can understand the results. Our honorable guest today is Judge Mark Juhas. He became a family law judge on August 23, 2002, appointed by former Governor Gray Davis. He has been an adjunct professor of family law at Southwestern Law School. He received the 2011 Judicial Officer of the Year Award from the California Lawyers Association, and in 2016 received the Outstanding Community Service Award from Southwestern Law School. And I can attest to that because I got to hear Judge Juhas at a seminar that I was taking as a document preparation company on special needs conservatorships. Not only was he knowledgeable, but really entertaining. And those two components cannot be beat. Judge Juhas, thank you for joining us.
It's my pleasure to be here today.
So first question, are judges completely free to make whatever rulings they choose in any area of law? And if not, how are judges required to decide on legal issues?
So in family law, there's tremendous discretion in a judge. However, judges are constrained by the law, not only the family code, which are laws that are passed by the legislature, but also through appellate rulings, which interpret those statutes. So if I make a ruling about X, the litigant can then appeal that ruling if they think that I've gotten it wrong under either the family code or under a precedent, under a ruling that's already happened in the past. So while there is tremendous discretion in areas like what is the best interest of a child, which isn't well defined, it's health, safety, and welfare, which are very vague terms. But beyond that, I am constrained by what the best interest of this child is, the health, safety, and welfare of a specific child.
Okay, so with that in mind, how different can judges be in the way they rule on a point of law?
It can vary greatly. As long as, I'm going to take spousal support, for example, because spousal support is a good one. You can put on evidence before two judges. And if you look at the family code under section 4320, which are the various factors, I think there's 11 or 12 of them, that talk about how a judge is going to determine spousal support, you can put on all of this evidence before two different judges. And as long as each one of those judges justifies their ruling and describes how they got to why they think this factor was important and that factor is not important, then it's probably not going to be disturbed on appeal. So each judge is going to weigh these various factors in a different way and determine, I may think that factor number 4 is really quite important in this case. Another judge may think factor number 4 is not important at all, that I really need to focus on factor number 7, that's the one that's really important. And, I think that if you put 100 judges in a room and gave them the same facts, they would, with some outlying exceptions maybe, everybody would be within a few $100s of each other. So I don't want to leave the impression that somebody's going to be $10,000 a month and somebody's going to be $500 a month. But there's tremendous discretion in these areas.
This is a good question because this comes up all the time with litigants. Does or can emotion factor into a judge's decision?
It shouldn't. And I guess the question that I would ask is, whose emotion? The litigant's emotion, or the judge's emotion, or the lawyer's emotion?
The judge's emotion. Because the misunderstanding, I think the misunderstanding is the litigant and the judge will eventually share the same emotional position on their issue.
I can just about guarantee that's not going to be true. That at the end of the day, the judge is a neutral observer of and determiner of what really happened. You're going to have one litigant is going to say black happened, the other litigant is going to say white happened, and the judge is going to have to decide whether black happened, white happened, or what shade of gray in the middle happened. And I think that many litigants come into court expecting that the judge is going to take their side entirely and say the other side is a horrible human being. And almost never does one side hit what I'm going to call an out-of-the-park home run in family law. Generally, the judge is going to take whatever facts both sides are presenting, is going to weigh them, and is going to determine, again, best interest of the child, for example, and is not going to become emotionally involved at all in the case.
I'm going to skip to child custody, and then I'm going to circle back to spousal support.
Sure.
Because both are so highly emotional, because both child support, spousal support, custody feed right into the core of the litigant's beings. So with child custody then, a hugely emotional issue. Here's what I hear before they go into court. I can't believe a judge would force me to share co-parenting time while I'm breastfeeding. That's just one example, and it comes up a lot. And this is a therapist model as well. So can judges use therapist model of child rearing in their decisions for the co-parenting schedule? And let's take breastfeeding as an issue.
Sure. So I'm a judge in Los Angeles County, and Los Angeles County Family Court Services, who are the mediators that before any judge can make a child custody order, the parents have to go to Family Court Services to try to mediate their agreement. That's true all over the state of California. It's generally true nationwide as well. I would highly recommend that parents sit down and, if they can, try to work out their disputes before they go in and have a judge tell them what they're going to do. But every county in California, and Los Angeles certainly, many other states have proposed custody schedules. And they're often broken down by age, distance, that sort of thing. So what's good for a 1 to 3-year-old is not going to be good for a 16 to 18-year-old. I mean, being honest. And so all of the Family Court Services people, again, generally true nationwide, have taken and come up with custody schedules that are generally good for children of various ages. So you can get those on the internet. You can Google child custody schedules, and millions will pop up. Arizona has a particularly good one, I think. LA counties are good. Many are very good. Most actually are very good. When you look at specific questions, though, like breastfeeding, it's going to be, it depends. I think I won't say many times. Occasionally, I think a mom will say, I can't give up custody of the child because I'm breastfeeding, and a judge may very well say, you can pump, you can, you can wean a child off, you don't need to breastfeed until you're X age, that sort of thing. And so then it becomes, it becomes a discussion where, again, is it in the child's best interest to give dad access to that child? Or is there a specific reason that child needs to be breastfed? It may be that, pumping simply doesn't work for that mom. And therefore you're in a situation where, breastfeeding is going to be, sort of the issue. But generally I would say that breastfeeding is not going to be used as a defensive shield to say, I can't share time with my child because I have to breastfeed. Most judges are going to, try to find ways around that. Okay,
and then just piggybacking on that, when a pro per litigant, somebody who is not self-represented, thank you, wants to present the therapist models of child rearing. How much can you listen or allow that into your consideration?
Well, so
like the attachment theory.
So part of every family law judge's training, not only at the beginning of their tenure in the department, but also on an ongoing basis, is going to be child development classes. We have, again, our family court services people give us what I'm going to call in-service, which is a bad word, but you give you the idea that, we have monthly meetings in our department, and I know that other judges do as well, and family court services will come in and, refresh everyone on child development milestones and that sort of thing. There are also organizations out there that judges can go to trainings and do often go to trainings that are put on by child development specialists, that are put on by other lawyers, that are put on by other judges, that sort of thing. So all those things are available out there.
This is great to hear.
Yeah, and so, most family law judges work very, very hard to keep up on developmental milestones and, all of that sort of stuff, so that I don't use, my kid's example. Well, I remember when my kid was that age, this is what happened, therefore that must be what's happening with your child, so that we're more in tune with general theory. And quite frankly, as research changes, as we get a little more sophisticated, there's more information, and thoughts have changed. In the very old days, the idea was tender years, which was a young child always went with mom, because a young child should always be with mom. And as dads are getting much more involved in child rearing and becoming much more involved in their kids' lives, we're more solidly on the best interest, which is, giving dads more access to children than tender years would have given years and years ago. So how much does that weigh? I think that a self-represented litigant, if it's a point that they want to make, then I think any information that they can pull from any source. Again, if you're a litigant here in Los Angeles and you can go to those family court services brochures, it's entirely appropriate to say, look, the family court services brochure says this is what's appropriate, Your Honor, and so let's try to focus on that sort of thing.
Okay, so this can really be a conversation.
Sure.
In court. Okay,
absolutely.
Wonderful to hear. Wonderful to hear. Let's go back to spousal support, because those were excellent example you gave. So I wrote 3 things down. What is the length of time? What is the Gavron warning? And how does domestic violence influence spousal support?
Well, so let's start with the easy one. In the state of California, everyone is obligated to support themselves and to support their children. And so in spousal support, we have a Gavron warning. That comes from a case in re Marriage of Gavron. And basically what that is a court is obligated to tell a support receiving spouse that you are obligated to become self-sufficient, self-supporting within a reasonable period of time. Again, that's not terribly well defined, but that can mean any number of different things. You could have a very short-term marriage where someone where the receiving spouse would receive support for a lifetime. You could have a long-term marriage where the receiving spouse could receive no support at all. There's no mandated amount of support time. There's guidelines. In a marriage of less than 10 years, under the guideline, it's not a hard and fast rule, it's a guideline, that spousal support should last half the length of the marriage. Again, that depends on all of the various factors. Is the receiving spouse able to work? Is the receiving spouse, does he or she need more education? Have they been out of the workforce for a very long time? If you have a 62-year-old person that's been a stay-at-home spouse for the last 35 years, they may not be employable very rapidly or at all. Or they may be very employable with a little bit of educational background and that sort of thing. So the time depends on so many different factors. Increasingly domestic violence is becoming a factor that the legislature wants judges to take a good hard look at. Things like a conviction for if a one of the factors is if the battered spouse would be the one that's paying support to the victim spouse. I'm sorry, the victim spouse and the batterer spouse.
Okay.
Let me get my terminology clear. So if the victim spouse is the one that's paying support to the battering spouse, under the law, that's really disfavored. And in fact, under certain circumstances, it's going to be prevented altogether. So you don't want the victim to be paying the batterer support. There's a couple of cases, one of which was pretty egregious, where the victim's spouse was paying the batterer spouse support, and the batterer spouse was chasing the victim spouse all over the United States to make the victim spouse's life miserable, and was supporting that through the spousal support that the victim was paying the batterer. So, but most cases are not quite that egregious. Nevertheless, the trend in the law increasingly is to not have the victim spouse pay the batterer spouse support. In some cases, it's precluded altogether. In some cases, it's just a factor to be weighed. Other areas where it becomes important is in pensions and some other community property areas, which isn't really support, but domestic violence plays a role in those areas as well, where the victim spouse is not going to have a financial obligation to the batterer spouse.
One thing I hadn't thought about until just now is if the community property split is in the millions, and each spouse walks away with millions, would that be an example of no need for spousal support, something as weighty as that?
Oh, sure. You're going to look at, is the spouse, for example, there's a provision in the law that says if the spouse has, at the end of the divorce, no responsibility for minor children and has a sufficient separate property estate at that point in time to support him or her, then yes, spousal support isn't appropriate. It could be that you have two parties that make roughly the same amount of money.
Right.
So if, husband makes $2,500 a month and wife makes $2,500, then there's probably not going to be spousal support that's going to go back and forth on that. Although it may be that because of let's say that the one spouse makes $2,500 but has taken on all of the community debt. The other spouse makes $2,500 but is not paying any of the community property debt. Then that may very well be that there would be some support that would go, across the line, if you will, to help equalize some of that debt.
And I think it's just worth mentioning as we end our conversation with spousal support that there is a calculator used to help initiate the conversation, right, about the number for child or spousal support?
Well, so child and spousal support are two entirely different things.
Right.
There is guideline guideline child support, which is presumptively correct. And that would be depending on what county you're in, would be the guideline calculator, either DissoMaster, ex-spouse. Child Support Services uses the statewide guideline calculator. They all come up with within a couple of bucks of each other what the number is. But it's a statutory formula. Spousal support, on the other hand, also has a guideline number that can be used in a temporary support setting, but never for a permanent support or after trial support. So that's limited only to a temporary support. Permanent support is after trial, or generally after judgment. So while you can certainly run a guideline spousal support number just to get an idea of kind of what the numbers ought to be, a judge cannot use it. It's reversible error per se if a judge uses a guideline calculator at the time of trial.
Thank you. Now that was new information.
There you go.
I appreciate that. Mm-hmm. Something else that I hear a lot, going to the family residence now. I can't believe a judge would order the house to be sold if this is where our children were raised. So, Judge, if both parties are in disagreement about selling versus keeping the house, what options do judges have in their rulings?
So it's really interesting because I think most people think that family law judges have all this power. And in truth and in fact, family law judges have a very limited menu of options. And the family residence is a really good example of that. at the end of the day, the family residence is either going to go to one spouse, the other spouse, or be sold. There's a very limited number of cases where the family residence cannot be sold, but can be awarded on kind of a temporary basis to one spouse or the other, allowing the children to stay there for some period of time. So, for example, the wife is living in the house. They have a 16-year-old child who is, going to graduate from high school. There may be a very significant reason why upsetting this kid's life right now would make a huge difference in that kid's life. A judge could say that the spouse could continue to live in the residence with the child until the child graduates from high school, at which point the residence is going to be sold. That, however, is an itty-bitty little tiny slice of cases. There's a number of factors that have to go into it. It's very difficult to prove that that's the best thing. The default, if you will, in community property is, if it's a community property asset, if the house was purchased during marriage, then it's half one spouse's and half the other spouse's. I am entitled to get my community property upon the date of separation, right? That's my money. And so the law is very much against giving you my money to hold for any length of period of time. It's very much in favor of, I get my money, you get your money. Pensions are much the same way. Other assets are much the same way. So if one spouse cannot buy the other spouse out, the equity in the house is $100,000, so the other spouse is owed $50,000. If the one spouse can't go to the bank, refinance, and get that $50,000 out and get that spouse off title, then the law is very much in favor of selling the house and giving both parties their money, separating. These people have decided they no longer want to be together, and the law is going to help them do that.
Thank you. Okay, let's go to hearings and trials. Please discuss the reality of time that a judge has to get to know a case before hearing the case.
So,
you have a lot of work to do.
Yeah, actually very little time. Everybody files papers which judges read before they come to court, before the parties come to court. And the judge will then, start the hearing. Hi, I see you're here today for this, custody of your two kids, 13, 15, that sort of thing. But the reality is that the judge is not going to know your family, your situation, as well as you do. The judge isn't going to know the ins and outs of your children as well as you do. And the judge, regardless of how dedicated he or she is and how long they've been on the bench, and maybe has some insight into sort of how families work as they consciously decouple, the judge is never really going to have as good an understanding of the realities of your life as you do. So hearings go very quickly typically. In some cases, or some courts rather, 20 minutes is considered a long cause hearing. Some cases take 5 minutes or less. And so things go very, very quickly. A judge may dispense with 15 cases or so in the space of a 2.5 or 3 hour morning. So things move at a pretty good clip.
So this now leads into my next question. What is the hardest part of your job when dealing with self-represented parties in terms of knowing the case and ruling on the case?
So self-represented litigants know what they're trying to accomplish. They often don't know what the procedure and the process to do that is, and procedure can be very important, and they often don't know what the law is. So, for example, it's not uncommon for someone to come in and say, I worked during the marriage, my spouse stayed at home, my money bought the car, which we purchased during marriage, which is a community property asset, therefore I should get the car, which isn't the law. It makes some logical sense, it was my money, but the law views each party as being a equal participant in the community. Even if they didn't make money, they stayed at home and kept the home fires burning while the other spouse was out making the money. So the the car belongs to both parties. And, when you explain that to a litigant, they'll, oh, okay, I get it. I understand. Okay, well, the car's worth 10 grand, so I owe the other person $5,000. Okay, I understand that. We're done. So I think the most difficult part of working with a self-represented litigant is that as I said, they don't know the process and they don't necessarily know the law. And so sometimes it's difficult to explain some of the more subtle parts of the law to them. But by the same token, dealing with a self-represented litigant can be very, very pleasurable from the standpoint of you're dealing with them, you're having a conversation with them, you're able to kind of get, I understand that, but here's really my question. Here's what I really need to know. And so rather than getting kind of off track, you can sort of get to the nub of the matter relatively quickly.
That's so nice to hear, because people are fearful. It's an environment you don't find yourself in every day in a courtroom, and you're talking about things you never thought you would talk about. Mm-hmm. So would it be helpful to you in regards in terms of how a declaration is written? So when you go to most hearings and even trials, declarations have to be written, which is the story.
Correct.
Of what they're asking about. Any guidelines on how they should write the story?
Sure. Tell me what you want up front. If, don't bury it on page 7 that I want full custody of the child. I want full custody of the child. I want sole legal, sole physical custody of, Junior and my daughter, and these are their birth dates, right up front. So I know a place that I'm starting. So I know what I'm looking for. And then go through this is why I want full custody. This is what the other parent did, or this is what the other parent didn't do. And, be honest. It's embarrassing. You're telling very personal things to a total stranger judge in front of a room full of other total strangers. And I get that can be very, very embarrassing. But nevertheless, that's how our system works. And so the more you put into your papers, it may very well be that the judge will say, I read your papers, I understand that. Let's not go through that in open court. Let's leave a little bit of that sort of between us, at least insofar as the rest of the folks in the gallery go. And let's just talk about, the questions I need to have answered. But also, when you're going through and telling the story, it is a story. And you're an educator, you're a teacher, you're teaching the judge what's important and what's not important. So as you're thinking about your declaration, think about what is important, why is it important, and how do I make it clear as to what's important and why it's important.
Nicely said. Nicely said. I think that's a real help, because it's just so overwhelming.
It is.
Yeah.
For everybody.
Yeah.
And again, you've got 8 years of history with the other parent. The judge has 10 pages worth of stuff to read. So maybe the 8 years are important. Most likely than not, it's the last 6 months or so that's really critically important. So keep your eye on, what are you trying to accomplish? What do you want to have happen? Tell the judge that's what you want and why.
So if the parties can't afford an attorney, what's the best way they can educate themselves on aspects of law for settlement in their particular case?
So a couple of things. There is a wealth of information online. Like everything else online, some of it's useful and some of it's not. If you go to, California has, the Judicial Council has a family law webpage that has hundreds of pages of good information about custody and support and all of those things. Many of the counties in California have their own web pages, which are good and have good information. Many lawyers have web pages, again, some of which have very good information and some of which don't have terribly good information. I think I would also think in terms of going to visit with a professional, maybe a mental health professional that you could, what I call, buy a couple of hours of their time. Perhaps you can't afford, $5,000, but you could afford $500, and sit down with a lawyer for a couple of hours and just say, these are my questions for a couple of hours. Call that limited scope or unbundling. States have different ethical obligations around that. Unbundling is very well respected in California and is something that I don't think we use enough, frankly, in California. So buying a couple of hours of a lawyer's time, buying a couple of hours of a mental health professional's time, that sort of thing. I think I would be very cautious about getting the information from, my second cousin twice removed that got a divorce 5 years ago, and this is what happened, and this is what she said. Also, there's 58 counties in California. Each one of them have a self-help center. And they're there to not provide legal advice, but they're there to guide you and to make sure that you're using the right forms and filling them out correctly and that sort of thing. And I know that document preparers do the same thing.
Yes, and I'm so happy to hear you support the fact that, yes, you can get information online, but you get the best information when you sit down with a legal professional. It is not being disloyal to your spouse to seek an attorney's advice or information. Both people should do that, should they not?
Absolutely.
Yes, and then you can come with information to your own discussion. You don't have to spend, as you said, $5,000-$10,000. You can spend maybe $500 or so, and this is subjective to what we make, but so worth finding the money, don't you think, to at least get your feet planted firmly on the ground with good legal information before you start making your deals.
Right, so it's easy to say that community property, you add everything up and divide by 2. And generally that's the case. But there's an awful lot of real estate transactions that occur. There are pension issues. There are stock issues. There are some very subtle community property parts of the law that really sitting down and getting some help from an expert really does make sense. And I think, coming into any discussion with some information is better than going into a discussion with no information. There's a law professor at Harvard that coined the phrase bargaining in the shadow of the law. And, it may be that, it may be that that the law says X, but you don't care. What you really want is Y. But knowing that the law says X gives you the opportunity to figure out, what's likely to happen at the time of trial. If you come into a negotiation and say, I want X, and there is no way you're ever going to get X if the matter gets litigated, then the other person has no place to go but to litigation, which is going to cost a ton of money and time and effort, and it's distracting, and it's all kinds of, if you can avoid litigation, that actually makes the most amount of sense. So, having an idea of what you can get, what you're trying to accomplish, what you can't get, should you decide to go the litigation trail, is really the way to go.
Can you tell when you have self-represented litigants, either at a trial or a hearing, that they have been educated?
Oh, sure.
It's obvious.
Oh, sure.
Do you find there's less arguing if they've gotten legal information?
I think that I think that's a personality thing. Most people, my experience, I've been doing this for a very long time. My experience is that most people really don't want to fight. Most people really just want to get it resolved. And, but my experience also is when people are separating, either never married and they're separating as a couple, or they are married and they're separating, one person is roughly 6 months ahead in their thought process of the other person. And so depending on kind of where, if people have caught up, there's less fighting if they're kind of both on the same page, and there's more fighting if they're really not on the same page. But having both people have a little bit of information often gives some parity, and then you're in a position where you know what you can do and you know what you can't do. And so you may be disagreeing about things, but the disagreement is slightly different.
Understood. And lastly, what would you say to listeners going through divorce now or approaching a divorce filing so that they understand the law and the court system most realistically? Is it just a little about what you said before.
Yeah, I think that the system is not without its warts. However, for the most part, I think if you approach the system understanding that the more you can resolve amongst yourselves, either with professional help or without professional help, the better off you're going to be, the smoother it's going to be. If you're not going to be able to resolve much and you're going to find yourself in litigation, understand that it's not going to finish quickly, that it's something that's going to take quite a bit of time. If you're going to hire an attorney, understand that it's going to cost a lot more money to do this than you think it's going to cost. For example, if you have an accountant, accountants are also very, very expensive. And there's a lot of disclosure requirements. You're going to have to be gathering a lot of information. As I said earlier, litigation is very distracting. When you need your best parenting skills or your best personal skills, you're going to be distracted from litigation because litigation necessarily takes on a life of its own. And so you're going to be responding to the demands of the litigation rather than the litigation responding to your needs. So just realize that, family law judges are doing the best they can, that they're working very, very hard. They're very dedicated. They do their reading. They keep up on the law and all of that. But you're not going to hit an out of the park home run. Everything's not going to go your way. And that, at the end of the day, things are going to end up pretty much somewhere in the middle, because that's kind of the nature of divorce litigation, and that's kind of the nature of the law as it's set up. So just realizing that nothing's going to resolve quickly, and nothing's going to resolve cheaply, and nothing's going to resolve easily should you go the litigation route, and just keeping those expectations, I think will keep you happier going through the litigation process. But sitting down early on and trying to resolve stuff is the best way to go.
I really appreciate the time you took. I know what your schedule's like. Thank you so much for doing this, Judge Juhas.
My pleasure. You're welcome.
And I think you've helped a lot of people. I really do. Well put, those answers. So thank you, everybody, for listening to Constructive Uncoupling, the podcast dedicated to amicable divorces. I'm Judy Weigel, your host. You can reach me through email, Judy, Judy, at constructiveuncoupling.com, or through my business divorce resource in Los Angeles. Thank you, and look forward to our next episode.